Greetings and welcome to another version or another issue of the People's Law School. Today we're going to be talking about personal injury law. I'm Craig Housman. I'm a lawyer here in Paducah. I've been practicing here since 1973. With me today to help explore this topic of common interest are two other Paducah attorneys, Shannon and Len Ogden. Kevin is a 1990 graduate of the University of Kentucky Law School. He practices here with the Bryant Law Center. His practice is limited to personal injury and other civil litigation matters. That's all he does. Len Ogden practices in Paducah by himself. His practice is limited to criminal law and personal injury claims.
And a little civil rights for the plaintiff.
All right.
Thank you.
That's certainly so. But I guess the easiest way to get into this topic is just for me to ask Kevin to start off with, what sort of personal injury claims do you receive the most phone calls about?
Craig, I probably receive the most phone calls about automobile accidents, followed closely by workers' compensation claims where people are injured at work. Mm-hmm. And then beyond those two areas, you get quite a few phone calls about the possibility of medical negligence, sometimes nursing home negligence cases, or someone feels that their loved one has been mistreated or not cared for properly at a nursing home facility. And then other various and sundry homeowners type issues, pets, playground equipment, and things like that. But far and away, the biggest volume of calls relates to automobile accidents.
One of the things that occurs to me from receiving the same sorts of phone calls that you're describing is how frequently people do not understand the Kentucky concept of no fault and who pays the medical bills and lost wages when there has been a collision, which at least in the caller's mind is clearly the other fellow's fault. What are the rules on this?
Well, in Kentucky, as you say, we have a no-fault system, and it sounds kind of unusual to people because the first two questions that people ask when they call generally is, who's going to pay for my car, and who's going to pay for my bills, my medical bills. And so on the medical bills, when they ask who's going to pay, I say, well, were you driving a car you own? Were you a passenger in someone else's vehicle? And generally the answer is yes. And I ask them, was that vehicle insured? And they say yes, but what's that mean? What do you care about that for? And I say, well, the insurance that covered the vehicle that you were riding in or driving at the time of the accident is going to be obligated to pay your medical expenses up to a certain limit. And they say, well, that doesn't seem right, but it wasn't my fault. And I say, well, sorry, that's the way it is. If you don't like it, talk to the legislature. So that's the concept of no fault in a nutshell, and the person is entitled to fill out a no fault application with the carrier, and the carrier then is obligated to pay their medical expenses as long as the bills are reasonable in amount and for the treatment of injuries reasonably related to the automobile accident. And there's a preset limit on how much they're obligated to pay. And the insurance company is also obligated to pay a portion of the wage loss as long as a doctor certifies a need to be off of work as a result of the car wreck.
Len, in our end of Kentucky, we're pretty close to some surrounding states which do not have no-fault coverage. What if someone is in Paducah and has an automobile accident and they're from a state where they don't have the no-fault insurance policy and yet they're injured, they've got medical bills? What do those folks do?
Well, correct me if I'm wrong, but I think they come under the no-fault law as well and receive the same type of benefits up to a maximum of $10,000.
Okay. Is there a possibility of there being more than $10,000 in no-fault coverage?
Yeah, sure. The $10,000 is the minimum amount that is written under the statute. And then you can purchase additional no-fault coverage. I think it's in increments of $10,000 up to, what is it? Is it 50 or 30?
I believe it's 50.
I believe it's 50 now, but I'm not sure.
I've seen them as high as 100, believe
Have
it
you?
or not.
I'll be darned. I haven't seen that. I've seen 50.
I haven't either.
I've seen 2 of them in the last 10 years, so there aren't very many, but I've seen them.
And it's probably a good thing, and the insurance adjusters don't seem, well, I haven't been to one in a while, but anyway, they don't seem to volunteer that information sometimes because you can buy the additional no-fault benefits in those increments for a fairly cheap or low premium. And I was carrying around $10,000, believe it or not, the minimum for a long time. And I had a reason to go over and redo my policy, and I think I boosted it up to about 30 or something like that. And the premium was just negligible increase.
So it's a good thing for someone to take a look at their own automobile liability insurance policy, and if at all possible, pay for as much of the no-fault coverage as they can afford. I know it's been my experience that coverage is more readily available with less fuss from the insurance carriers than certainly the liability coverage for the other car and certain other types of coverage. What's been your experience with that, Kevin?
I think you're 1,000% correct, and the additional coverage is relatively inexpensive, and it's also easier to deal with the automobile insurance on the PIP coverage than it is to deal with health insurance. For example, in the event the person that's injured in an automobile accident only has $10,000 in PIP coverage, you can run through $10,000 in medical bills pretty quickly. And if you have no health insurance, of course, you're stuck. You're between a rock and a hard place at that point, because the insurance company for the person that caused the wreck is not going to immediately step in and take care of medical bills. And if you've got health insurance, you can turn the bills into health insurance, but health insurance is only going to pay a percentage of the bill, and it's subject to deductibles and co-pays and non-covered services. For example, nowadays in most health insurance policies, there's a limitation on the number of physical therapy visits that the health insurance carrier will pay for in any given year. Most of the times now I see 15. And so you can pretty quickly find yourself in financial difficulty with respect to medical bills. Okay. So it's really worth it to talk to the insurance agent and purchase additional no-fault coverage.
That way you're taking care of yourself and the people you love, or the people that you are friends with enough to have in your vehicle, instead of just buying coverage that would protect the other fellow.
That's correct, because the $10,000 basic coverage is going to apply to any person that's in your vehicle, regardless of whether you're related to them or not. And if you've purchased additional coverage, people that you're related to by blood or marriage and are residents of your household and in your car and get hurt are going to be entitled to make that claim for additional no-fault benefits.
And one of the important things along this line is that if you have the no-fault coverage and you have health or medical insurance coverage, then there's a case in Kentucky that says that you can ask the health insurance carrier to pay the medical and ask the no-fault carrier to hold off on paying any medical and to pay your wage loss up to a certain amount. And there is a limitation on that. What is it? Is it still $200 a week, I think?
That's
maximum.
The basic minimum.
That's the basic, yeah, correct.
If you get added reparations benefits, which is the technical term for purchasing more than the $10,000 basic reparations benefits, then the amount of wage loss protection goes up. But that's a matter of what the policy says as opposed to something in the law.
That's correct. And of course, as you said, Kevin, medical insurance carrier is only going to pay a percentage and their co-payments and all that. But nonetheless, if, say, you incur a large bill at Western Baptist Hospital and you turn that into your health insurance, and they make a whopping big payment on it, Western Baptist is probably not going to push you too hard after that payment and give you some time to pay. And then you can go back to your no-fault policy and pull in your income loss up to the whatever the maximum amount is. At least you have something coming in over the next several months until that $10,000 is used up. Otherwise, the $10,000 might all go to Western Baptist for the hospital bill, and you get nothing to give you some relief on lost wages during the pendency of the claim.
One or 2 points that we need to clarify. We've talked about PIP, and we've talked about no fault, and we've talked about basic reparations benefits and added reparations benefits, and essentially those all refer to the same thing, which is just no fault benefits. And one thing that Kevin said that I want to put a little caveat with, and that is, I know there are some insurance policies that, with respect to the added reparations benefits, divide insureds into 2 classes. So if your high school friend is riding in your car, but he's not related to you by blood or marriage and doesn't live in your household, he may be only entitled to the basic reparations benefits of $10,000, even though you have paid extra to have the additional coverage for members of your immediate family. So once again, this is something which I think some insurance carriers draw a distinction in, and so you just got to look at the policy.
Yeah, I think all of them do, pretty much, and that's the point I was trying to make. The people that are not related to you by blood or marriage and don't reside in your household, they're only going to get the benefit of the basic 10.
Right.
But your other family members would get the benefit of the added reparations.
Now, remember y'all corrected me on that last year when I was telling the story about my mom buying all the extra coverage and carrying the little old ladies who played bridge around in the back of the car. So I remember that very well. That it gets confusing, and you know, if it's confusing sometimes for us as lawyers, and I'm willing to admit that, think what it is for the public, general public.
And it's a reason I think that that people would be well advised to contact a lawyer pretty soon after they have an accident, just to kind of get the lay of the land, as it were, because by state law they have the right to direct the payment of their no-fault benefits among the various elements of loss, wage loss, and for medical expenses. And there's another element of recovery that we haven't discussed, which is called replacement services. So for example, if Len routinely mows his yard and he's been injured in an automobile accident and he can't get out and mow his lawn, and he has to pay someone to do that for him, he can be reimbursed from the automobile insurance company.
Let me ask you a question.
For that particular payment.
What if I either can't get out to mow it or I just rather not? You know, and my wife mows it, and I normally mow it. What's the effect there? Does she get paid anything?
I don't know. I've never encountered that.
Well, I just thought I might sometime. But I guess the important point then is, in a way, we have books. And we can go to those books or our computer, which has an online law library essentially, and get the answers to these things when we get questions that come up that may not be the routine everyday thing we deal with.
Well, and the people need to know that if they wanted to reserve some of the money for the wage loss, say they know they're going to be off for an extended period of time, and they know they're going to need some help around the house, they may want to reserve a pretty good portion of the no-fault benefits, if not all of them, to pay for those type losses. Whereas if they don't make the direction, and the insurance company writes one check to the hospital, that may exhaust the limit.
Right.
And then the injured person will get a nice letter that says, thank you very much, we've paid everything we have to pay for you, good luck.
Right. And then the next time you go to your doctor's office and he's inquiring about the bill being paid, or his dragon at the gate is inquiring about the doctor's bill, and you're just standing there with your hat in your hand.
Right.
One of the things that has become a fact of everyday life in handling injury claims that we haven't touched on, that affects the choices people make with respect to which bills get turned in to whom, is the issue of subrogation rights. I know when I started practicing in 1973, and I think Len started in 1974, this was sort of a no-brainer sort of thing. The subrogation still existed, but you didn't have some of the complications that have arisen as a result of some of the federal and state statutes that have been passed. For instance, the Employee Retirement Income Security Act of 1974 has made a 600-pound gorilla out of a number of health insurance carriers. Those choices those factors also play a role in terms of to whom you submit medical bills, would they not?
Yes, they do.
Would one of y'all please address that?
Well, the thing that I think everybody needs to understand is that in most health insurance contracts nowadays, there's a provision called a subrogation provision or a reimbursement provision. And essentially it says if the health insurance company has to pay medical bills because someone is hurt as a result of someone else's negligence, and a claim is made and there's a settlement or a recovery, then the health insurance wants its money back.
All of it.
All of it.
Every penny.
Every penny of it.
Even if the person who's hurt isn't paid in full, even if he's had to pay a lawyer to get that recovery?
Even if. And as you say, that's come about primarily as a result of the Employee Retirement Income and Security Act, commonly known as ERISA, and I think it's a misnomer because, at least in this instance, there's no security for the employee. They seem to get the short end of the stick. Now, that right is to a certain degree negotiable with most of these health insurance carriers, but because of federal law and cases that have interpreted the federal law, the health insurance carrier on an ERISA plan carries a big stick. And then there are two other instances that come up frequently that are similar. One is Medicare and the other is Medicaid. If Medicare pays bills, they're entitled to get their money back. And if Medicaid pays bills, Medicaid's entitled to get its money back. And Medicare's reimbursement is 2/3 of whatever they pay, plus a pro rata share of the expenses on the recovery. And by state law, Medicaid gets 75%. And they're generally pretty easy to deal with, although Medicare takes a really long time.
Right. And that's been my experience as well with respect to those. But all of this is something that it pays the person who's been injured to get some advice on the front end, because by comparison, if the person does not have to have the income replacement aspects from no fault subrogation rights are completely by statute secondary to the injured person, and unless the injured person is paid in full, then the no-fault carrier does not get its money back.
That's correct.
If there's enough money to pay everybody back, then that's fine. But it makes a big difference out of which pocket you choose to get the medical bills paid, or it can.
And that can also be true with Medicare, because Medicare will take a completely different position with respect to its claim if the injured person has received all of his or her no-fault benefits in the form of wage loss, or replacement services.
Len, what's the next most common question that you get from telephone calls about personal injuries? Or what's the next most common area?
Well, believe it or not, I think that fall downs are becoming more and more common. I don't know whether that's everywhere. I don't think I heard you mention those in your listing. You might have down the line, but they weren't certainly in the first 3 or 4. And for some reason, I seem to get a lot of those calls. Call them slip and falls generally. And I think people are very, very confused about the law, and I can understand it. A lot of people call in and they don't understand if they fell over at their friend's house or a family member's house over their own feet, or just fell down the steps for no reason at all other than they just perhaps were being awkward at the time. They think that they should recover. And there may be some coverage there under a homeowner's policy for medical expense that's been incurred. So there's a possibility of getting some payment on medical expense. But what they don't understand is that they have to prove that on their claim that there's negligence on the part of the party that they're making the claim against in order to recover the usual damages such as pain and suffering or permanent impairment of power to work and earn money, or medical expenses greater than whatever the medical coverage policy limit may be. And so I seem to spend a lot of time, and it's kind of the same way sometimes with automobile accidents, but I seem on slip and falls to spend a lot of time trying to explain to people that just because you fell there, there's not an automatic recovery on a claim. You've got to have maybe a liquid on the floor in the kitchen that should have been cleaned up that they fell on, or maybe there's a chipped step that should have been fixed. Those types of things may create negligence. In other words, the negligence is where a homeowner in that instance has a reasonable duty of care to provide a safe area, safe environment, and so forth. And if they breach that duty or violate that duty, even though it's unintentional, then that's negligence.
Kevin, does it make a difference what the circumstances of the fall are in terms of whether or not it's a commercial establishment as opposed to the example Len was using where he's talking about a fall in a private home?
Yes, it would. There are 2 or 3 different categories of people that come onto property in the law. They're generally guests or invitees and licensees and all kinds of names that probably wouldn't make a lot of sense to people. But if you're the homeowner or the property owner, your obligations may be different depending upon whether the person on your property is an invited guest or whether that person is coming on the property to perform some kind of service for you. So overall, I think the overriding issue is does the person act in a reasonable manner in warning people that come on their property about conditions that are dangerous or conditions that might cause someone to be hurt and that the person might not be aware of if they're not told about them. And I think that's the overriding issue.
Len, is there a difference, some different standard that would be applicable, say if I were a customer in the Acme grocery store and I was there as I think that's properly categorized as a business invitee of the grocery store. Is there a difference in the obligation that they owe their customers as opposed to what I would owe as a social guest if I had invited you to my home?
Well, perhaps to a degree, in the sense that if you are if you're a customer in somebody's place of business, then they have a duty not only to warn or clean up if you have, say for instance, liquid on the floor, and I'll just use that as an example. There could be all types of other defects that could cause a person to slip and fall. but they also have a reasonable duty to discover. And so you'll find places like Walmart, if you end up suing them upon behalf of a client, and they'll claim, and I'm not saying they don't, but they'll claim anyway that they have somebody that's assigned to that duty to walk around the store on a regular basis every so many minutes and make sure that the floor is clean. And that way, if you fall on something, say a liquid, and claim that they should have discovered it and should have cleaned it up within a reasonable period of time, then they'll claim, well, we made the reasonable attempt to discover it because we sent the little person around to look and they didn't see it. And that was, 5 minutes before you fell, or 10 or 15 or whatever the time period might be. And they try to defend that way. In a homeowner situation, I don't think that in most instances that you have to go quite to those lengths. But if you know that there is a defect, latent defect, or even an obvious defect that might cause a slip and fall, then you need to either clean it up or warn the person. And you may not have quite as high a duty as far as this discovery, although it kind of blends together to a certain extent. Now there are other situations such as Greyhound buses. In areas where there are really dangerous things like dynamite that's being used, where there's a higher duty. Of course, that's normally not going to involve a slip and fall.
Okay. One of the things that always struck me as being subject to common misunderstanding is the liability or potential liability of a premises owner to his tenant. In other words, if I have an apartment building and there are 4 apartments in this building, is there a difference in the duty that I would owe my tenant as contrasted with if I had a retail business in the same building, the duty that I would owe my customers? Kevin, do you?
I don't know exactly what your obligations would be. My last foray into that area of the law, as I recall, indicated that if I'm the landlord and I lease an apartment to a tenant, then the tenant takes that apartment as it is in the condition that it's in, and I'm not then liable to them in the event they somehow get injured while they're using that apartment. Now, there's a distinction between that apartment and, say, the common areas. If it's an apartment complex, the parking lot is used by all of the tenants. Stairwells that might be common to all tenants. As the landlord, I still have an obligation to keep those common areas of the property in good repair, and as Len has indicated, I would be obligated to repair or warn of dangerous conditions that people wouldn't reasonably be expected to become aware of.
And many times these duties can turn on contractual agreements. For instance, the landlord might not be able to totally delegate his duty away so that he's not responsible to, say, a business invitee that comes into the premises that he's leased to a particular business. But he could, for instance, possibly at least share the liability by putting into a contract that, say, the common area is going to be maintained by the lessee. In other words, the business that's leasing the premises from him. And I've gotten into some of that. And it can, when you've got one landlord and 3 tenants in a shopping area like a strip mall and 1 parking lot, it can get really confusing. And that's where you've got to get in and do a lot of reading concerning the contracts as well as what the law is that's applicable. Now, I did have let me go ahead and say one. I did have a situation on an apartment one time when I was a young lawyer, and I won the case. I didn't get a lot of money, but the apartment was leased to a gentleman and his family, and the ceiling fell in. And, as Kevin said, normally if you lease that apartment, the interior, is going to be the problem of the person that's leasing it or that's leased it. So, for instance, if, I have a liquid on my kitchen floor, my wife falls on it, and I was the one that put it on there, then that's my problem. You can't blame the landlord, of course. But if a structural thing happens, such as a ceiling falling in, it may be that the duty is on the landlord to have maintained that properly and therefore may be liable to the tenant if the tenant's injured.
Sometimes you also get into these odd fact situations that kind of create a double-edged sword. I've gotten several calls through the years where a tenant says, I told the landlord 2-3 times over the last month, I've got a problem here and you need to fix it. And let's just say steps, for example. There was a tread that was rotten on the steps. And then it turns out the person actually gets injured because the tread on the step gives way. And if that's the only way in and out of the apartment, maybe there's a claim there. If there's another way in and out of the apartment and you've got a bad set of steps, the law would probably require you to, if it's reasonable to use the other way in and out of the apartment, you better use the other way in and out of the apartment.
Or if you're aware of the defect, you have an obligation to fix the defect and then charge it off to the landlord by deducting from rent.
Okay. The hypotheticals each of y'all have been talking about raise a subject that I don't think a lot of people understand unless they've been on jury duty, and that's the doctrine of comparative fault and its application in Kentucky. Would one of y'all please explain that?
Well, everything adds up to 100%, it seems like. So anyway, if you've got somebody that's claiming that another individuals, company, whatever, was negligent and violated a duty of standard of care and should have to pay you on your claim, they can come back and claim sort of in reverse as part of a defense that you were comparatively negligent. In other words, that you did something that violated some duty that you had to be careful and try to keep yourself safe. So what juries can do sometimes where there's evidence that both parties, the suing party and the party being sued, have been negligent, the jury can be instructed by the court that they can find the parties comparatively negligent. In other words, taking the 100% I was talking about a little bit earlier, they could put 50% negligence on one party and 50% on the other, or they could do it 75-25, whatever. And say, for instance, if they put 50% on the party that's being sued, the defendant, and 50% on the plaintiff that's doing the suing, then if the plaintiff gets $100,000 in a recovery on damages, the judge will take out his calculator and will take 50% of that off and reduce it, and the plaintiff will end up with $50,000 because of his 50% fault.
Thank you. One of the things that we've sort of talked about is what damages, what elements of damage are properly recoverable under Kentucky's law for someone who's been injured as a result of another person's negligence. Perhaps it would be useful to explain that, item by item in terms of what is recoverable, where the person is either injured or if they receive the ultimate injury and are killed. Kevin, what are the basic items of recovery?
Well, you've got possibility of a property damage claim. If someone damages your property, for example, in a car wreck, if they damage your car, you would have a claim for the damage to your car. Then in terms of personal injury, regardless of how it occurs, you've got a claim for medical expenses. Medical expenses you're reasonably certain to incur in the future as a direct result of the accident. For wage loss, for permanent impairment to the power to labor and earn money, and then for pain and suffering. In certain circumstances, a person might have a claim for punitive damages, That is, if the defendant does something that's grossly negligent. For example, they're under the influence of drugs or alcohol, driving at excessive rates of speed, maybe in the case of an intentional tort, say where I intentionally assault you, I intend to hurt you, I could be assessed punitive damages.
And those are over and above what it takes to compensate you.
Over and above those first 5 elements of damage that I mentioned. And then beyond that, you've got the possibility of loss of consortium claims. And in the event of the ultimate injury, which I would say is wrongful death, you've got a claim under the wrongful death statute. The beneficiaries under the statute do, that is, for burial expenses and for destruction of the power to labor and earn money.
Okay.
I think those are the basics.
That's right.
How, if it is Kentucky's rules so far as recovery for wrongful death different from what we would see in most of the rest of the states?
Well, Kentucky is one of only 4 states in the nation now that do not allow for the surviving spouse to recover for loss of consortium, that is, the loss of the relationship with the spouse that gets killed. And I think it creates an extremely unfair situation. For example, if my spouse were somehow injured today and broke her leg, I would have a claim in theory for loss of consortium because my spouse broke her leg. But if she suffered the ultimate injury and she were killed today, I don't get anything. I don't even have a claim for the loss of the relationship. Now, I can recover for the burial expenses, so she's able to be buried. And I would be able to make a claim for the destruction of the power to labor and earn money that was brought about as a result of her death. But it just seems extremely unfair, and Kentucky is out of step with the majority, the vast majority of the other states in the nation, in denying this means of recovery.
And it is unfair. And you might have a mother that loses, say the mother is 60 years old and she loses a son that's 40 years of age. And she and that son are very close. Maybe he even lives in the same household with her. She's not going to be able to recover anything for her emotional and mental anguish and so forth as a result of the loss of that son. Now, there is a statute, and again, y'all correct me if I'm wrong on some of these things, but I had a case that involved this where 2 infant children were killed, and the mother could recover, I believe, for some type of loss of consortium claim up to age 18. That she was not going to have the children and see them grow up and that type of thing. So if you allow that, and if I'm correct about that statute still being in existence, then it would only make sense that you allow the same thing for a husband or a wife, or maybe even a mother or father. And I had a claim where a lady was killed out here in Ledbetter. It was a head-on collision. Wonderful lady. And she died either right at the scene, it's been a while back, or just about the time she got to the ER, the emergency room at the hospital. And there was only a short window there of maybe 30 minutes or an hour. And of course I couldn't get the judge to even open the door for me on that to allow me to claim a loss of consortium because at the time the husband didn't even know that she had been killed.
And what you're talking about, I believe, with that example, is the fact that under existing Kentucky law, the surviving spouse can recover for loss of consortium, but only during the period of time between the negligent injury and the time that the spouse dies.
Say if the injury occurs and then the spouse lays in the hospital for 3 weeks, then I suppose you can make an argument for loss of consortium damages for the period of 3 weeks until the time of death. In my instance, like 30 minutes or an hour, and the judge just was not going to open the door on that, especially since my client didn't get notified for a little while, and he didn't know that she had been injured and couldn't have suffered during that period of time a loss of her because he wasn't notified that she was in the accident until after she was deceased. But I was trying to open that door so a jury might plug some money in and do what was right, even though I didn't think the law was correct.
And Kevin, one of the things that you mentioned that I wanted to go back to just a little bit is you used as a hypothetical, if your spouse were to be negligently killed, that you would have a right to recover for the destruction of her power to earn money. If you have children, would that be strictly true, that you would recover all of it?
No, that would not be. Actually, the wrongful death statute sets out statutorily who the beneficiaries of a wrongful death claim would be. And if there are children, then the surviving spouse by statute is not entitled to all of the recovery. The surviving spouse is entitled to half, and then the child or children share in the other half. And the statute provides for all kinds of different scenarios. I just took the easiest one, which is a surviving spouse with no children.
The cleanest way to say it is that the wrongful death benefits or damages do not go by will.
Okay.
Yeah, and they don't go, if a person doesn't have a will, they don't go by intestacy either. They go by strictly by the wrongful death statute.
That's correct.
And I guess that's a point that people aren't always aware of. And another thing that people aren't always aware of is that in that situation, there's only one person by law with the legal authority to pursue the claim, and that is the personal representative of the estate.
How is that different from, say, the surviving spouse or the parent
Well,
of a dead
there's
child?
a presumption that if the surviving spouse wants to qualify as the personal representative, that they can, but that doesn't, it's not a requirement. So sometimes a person may leave a will. They may have selected their favorite, most trusted brother to be the executor of an estate, and that person may have the legal authority to pursue the claim, but they're actually not pursuing it on behalf of the estate. They're pursuing it on behalf of the beneficiaries under the wrongful death statute. A little confusing, but people, they're sometimes confused about who has the right to come in and talk to the lawyer and hire a lawyer and pursue the claim.
And it makes some sense, doesn't it? Because otherwise, let's say that you had somebody and they died and they had a surviving spouse and they had 10 kids, children, all over the age of 18. I mean, you might have everybody in the world going in there and filing a lawsuit with a different lawyer if you didn't have this statute that designated the person that was to bring the lawsuit, that being the personal representative, or usually what we call the executor or administrator of the estate.
Okay. Well, we are sitting here in late April, and the warmth and softness of spring is upon us, and we are living in that part of the world which is blessed with lovely lakes.
Are you going to read a poem now?
No. But in the spring, a young man's fancy turns toward fishing and boats and that sort of thing. What are the legal concepts, or what are the things that, from a lawyer's perspective, somebody might ought to do, as well as cleaning out their tackle box before they decide to get on the waters this year?
I think Kevin and I both decided neither one of us knew a heck of a lot about boating, but I'm going to vote for Kevin to give you the answer.
I'll take it. My best advice to anybody that owns a boat is right now, go to your insurance agent, talk to him about the boat that you have, its size, its use, where all you intend to use it, and ask your agent to review your insurance coverages to make sure that you've got coverage, insurance coverage on that boat in the event you cause damage to someone's dock, or you cause personal injury to someone that is in your boat as a passenger, or you cause injury to someone in another boat. Because I think that most people assume that their homeowner's coverage is going to cover them and the operation of their boat. And my experience is that's not always true. The policies vary from company to company, but as a broad generalization, the homeowner's coverage is only going to cover certain types and sizes of boats. And if you're not within the coverage, you may be out there and not be protected in the event you cause someone to be hurt or some property to be damaged.
And the time to check is before the accident
Correct.
happens, not afterwards.
And another odd situation that I've seen arise is you got to get the boat, in most instances, from somewhere on land, and you tow it over the roadways, and then you put it in the water. You need to check with them on your auto insurance policy to make sure that you have coverage for that trailer as you're towing that trailer down the road, because once again, there are limitations on coverage in automobile policies depending upon the size and length of the trailer.
Yeah, towing exclusions is what they're called.
Okay.
And the other thing is, are we out of time yet?
No.
All right, the other thing is that I just know from doing a little boating myself that people just think that these boating accidents are so freak. That, in other words, that they just rarely occur. You know, now we all know that automobile accidents are happening every day. Well, I think there are probably more boating accidents than what we're aware of. But the key here is that if you have one, there is a darn good chance it's going to result in death or a very, very serious physical injury, because you're dealing with water as well as in drowning and those types of things, as well as with just a vehicle that travels on a surface like water. And so you can be in a situation where you can say, oh, I don't think I really need coverage, and then that freak accident occurs and it can wipe you out.
I've also noticed the trend seems to me that more than in any other circumstance, when you have a boating accident, there's frequently a relationship to alcohol. And I think it's because people are out at the lake, they're off from work, they're having a good time, they're enjoying themselves, they may have something to drink, and then a tragedy occurs. And of course it's illegal to operate a boat under the influence of drugs or alcohol, just like it is a car. So I think people need to be aware that they've got an obligation to comply with the law and exercise reasonable care in how they use their boat.
And when that tragedy occurs, you know, unless you're involved with another boat, when that tragedy occurs, it's usually going to be somebody that's kin to you or a good friend of yours on that boat. And, you know, it's a shame not to be able to provide what's needed in the way of medical coverage and other things by being properly insured. And it can destroy the friendship if the friendship could be maintained otherwise.
I just know that that was brought home to me in a real personal way when I checked one of my own policies that I had assumed was covering my fishing boat, and it covered boats up to 16 feet. My fishing boat is 16 feet 3 inches, and I know exactly how that would play out if there were a major claim. That 3 inches would cost me my coverage. So it's just a word to the wise to check on those sorts of things. What if the person who is involved in the motor vehicle accident that we started out talking about was on the job running an errand for his boss at the time? Does that bring other areas of the law into play?
Certainly could. They'd have a work comp claim, and by law in Kentucky the work comp claim would be primary, and the work comp insurance carrier for the employer would be obligated to provide the primary benefits for the medical expenses and for the wage loss, although the formulation on the wage loss is different than it is in the automobile accident, no fault fact circumstance. And then in addition, you'd still have the automobile accident claim. So there's, and it happens frequently, where somebody's involved in an accident at work while they're within the course and scope of their employment. And it usually is either they're injured in an automobile accident or they're injured by some defective product or piece of machinery that they're using in their job.
And it can bring into play if the employee causes an injury to a third party, then there may be vicarious liability. In other words, not only is the employee liable, but he may in turn impute to the employer, under what we call the fancy term of doctrine of respondeat superior, liability to the employer. In other words, the employer is responsible for the employee's acts when he's acting in the ordinary course and scope of the employment. I read an interesting case the other day, and it happened in Paducah, and I won't mention the name of it, but I was doing some research on this area of vicarious liability. In other words, if my agent or my employee does something negligent and injures somebody, then I may also be responsible even though I didn't do it. But I'm responsible because my agent or employee did it. And it was a fellow that worked for a car dealership. And he fired at the tires of a vehicle that was, I guess, pulling out of the dealership. Don't remember the exact facts, but it was close to that. And apparently they were trying to repossess the car because he hadn't made the payments. And the fellow was wrong that was driving, but the fellow was liable that did the shooting. And the car dealership tried to say, well, we didn't authorize him to fire these shots at the tires of this car to try to repossess it, and therefore we're not liable, and he was acting beyond what we would have authorized, beyond the ordinary course and scope of his employment. And the court said, no, the car dealership is liable. We're going to look, I think is the way they differentiated it, we're going to look at whether what he was doing was for the benefit of the car dealership, even if it was wrong. And of course they found that it was. Okay. So whether you remember that case or not.
I think so.
And you probably do too. But anyway, I'm sorry at the expense of the people that are involved, but I got a good chuckle out of that case and the way the court looked at how they were going to determine whether or not the employer was having his employee act for him.
Well, it really kind of makes some sense, because it is, after all, the employer's business that's being carried out. And in order to have a successful business, unless one person does it all, he's got to hire other people to do work for him. And since he's the one that's trying to make a profit from carrying out this business, then the law imposes upon the employer an obligation to be responsible for any tortious acts that occur in the carrying out of his business. And even though that one does sound like it's pretty extreme.
Now, if somebody had just driven onto that car lot and had no real relationship with the car dealership, and the employee had fired and, say, shot the fellow because he just didn't like him, they had an altercation somewhere else, the employer likely would not have been liable for that, even though it happened on the dealership business, unless the employer knew that he had a propensity to shoot people. Well, that's the law.
Yes, it is. One of the other things that I suspect we all get calls about is someone who, either themselves or a loved one, has had a really bad result from some surgery or other medical treatment. What are the rules in Kentucky so far as the liability of the healthcare provider to the patient?
Well, the name of the case is the claim is medical negligence or medical malpractice. That's primarily what the lawyers refer to them as. And it's we use the term negligent in talking about, say, if we're going to have a claim against a doctor, we say, was the doctor negligent or was he not negligent? But it's a little bit different is compared with the definition of negligence, where somebody creates a situation or allows it to exist that causes a slip and fall, or runs into somebody with their motor vehicle accidentally as a result, say, of not stopping at a red light. And with a doctor, you have to demonstrate, or with any medical provider, that there was a deviation from the reasonable standard of care that would have been applicable to another physician of like type, or who did like procedures under the same or similar circumstances. To nutshell that down, there is a standard of care that medical providers must provide, and if they fail to meet that standard, it may not be the best care in the world, but if they fail to meet that minimum standard, then they may have committed medical negligence.
Couple of points, Kevin. Is everyone who has a bad outcome from surgery or other medical procedure, do they have a valid malpractice claim against the physician or the hospital?
No.
Is there something special that a person has to do who is making a claim against a physician or a hospital in order to establish whether or not they have violated the standard of care? Something that's different than if we were talking about whether or not a truck driver were negligent or a retail store were negligent.
Yes, probably so. As Len indicated, most doctors and procedures have a particular standard of care that applies to what he or she is doing. And the court will require a person that believes they have been injured as a result of some deviation from the standard of care to actually have an expert opinion to that effect. Now, the expert opinion is going to come from another doctor that reviews the facts and circumstances, reviews the records, and has some knowledge about what, in fact, the standards of care are and whether there was a deviation, and beyond that, whether the deviation from the standard of care actually caused the person to be injured. So it's a very rigorous test, in my opinion anyways.
One of the things that I think we owe an obligation to the public that's stayed with us for this hour to explain is, are there different time limits on the various types of claims that we've talked about today? In other words, how long do you have to bring one?
The answer to that is absolutely, and that's dictated by the legislature, which passes written laws. And for instance, on a slip and fall case, it's going to be 1 year in the state of Kentucky from the date of the injury. And if we're on a motor vehicle accident case, it could be 2 years or it could be 1, depending upon the whether or not no fault applies. And I'm not going to stop and explain that. Civil rights case for the plaintiff for violation of constitutional rights, 1 year. Federal law uses the state law on personal injury. Are we out of time here?
Just about.
All right.
And I want to be sure and cover that the medical malpractice claim is a strict 1 year from the date of the negligence. There are a few things that will extend it, but nothing else, like workers' compensation, car wrecks are 2 years.
And let's make one other thing real clear, and that is that the statute of limitations means that if you file your lawsuit after that, then you're going to be barred. You're going to be subject to having it dismissed.
And the other thing that people need to know is you can have one set of circumstances, you can have 2 or 3 separate claims, and 2 or 3 separate statutes of limitations, so they need to act quickly.
Yeah. 2 years on a no-fault auto accident, 1 year on the related loss consortium.
We want to thank the folks who have been listening to us talk about personal injury law in Kentucky. And this wraps up our program on personal injury, brought to you by the McCracken County Bar Association and the local television facility.